Bill Henshaw here again from the local constitutional counselor in California. And in this video, I'm going to tell you that I'm already doing the paperwork. I'll have it finished certainly next week, if not earlier. And I am going to be sending my documents and pleadings directly to the Supreme Court of the United States. And I'm doing it in their original jurisdiction, not the BS fucking appellate jurisdiction, which is absolutely meaningless today. You don't get anything done there. It's rare that anything happens, and certainly nothing um, in that relates to the original intent of those racist framers. But the current justices know now. This is what's so exciting. That when we get there in their original jurisdiction, that's not optional. We have a right to be there, secured by the Constitution, and you're going to learn all about that. Send me an email, youwinnincourt@gmail.com, and we go from there. And the great news, by the way, is we are going to be serving whoever the what I call the principal perp in your case is, and that could be, for example, a corporate landlord or a mortgage banker, or a quote unquote state governor or whoever the hell it is. We're going to be sending them the pleadings that we're sending to the U.S. Supreme Court in their original jurisdiction, and they're going to get lawful service process. And you're going to learn, by the way, that's something that you never get. Send me an email, youwinnincourt@gmail.com. And lawful service process is an essential element of judicial process, but you never see it because it's not there. When you get served, just so you know, and you're going to learn all about this, send me an email, youwinnincourt@gmail.com. When you get their service to process, and it's all in capital letters, and with the CA in my case, and the zip code, you just got served in my hometown of Washington, fucking D.C., not California. That's section 1 of that nefarious 14th War Amendment. All persons born or naturalized in the United States and subject to the jurisdiction thereof. Well, we don't fit the mold there because, we're born, in my case, in the state of Maryland all those years ago, Tacoma Park, Maryland. And as such, I'm a state citizen. And by virtue of that state citizenship, I'm a United States citizen. And that's the way it should work for all of us. And by the way, I have to back up a little bit here because when I say all of us, I mean all three white male and 21. And yes, that's a white supremacist argument, but that's the winner chicken dinner. Others, Africans and Asians, for example, are inhabitants of territories or inhabitants of states, but all of you have enforceable rights. Now you have them and you can invoke them, whether that's trial by jury, for example, among other things. And now you can get these rights just like we can, and they can't force you into their corrupt administrative tribunals either because you have creator endowed common law rights. And that's the way it should be. And we get back to that government, the Federated Republican form of government of defined and limited powers. We can go from there, make changes, and do it consistent with the Constitution, not in outright opposition to it, like with the 14th and 15th War Amendments. And by the way, as you'll learn, we really only have 12 amendments. Send me an email, youwinnincourt@gmail.com. But yeah, if we do it right, that's one thing. If we don't do it right, then what that says is we can just amend the Constitution and make things up out of thin air. That's not how it works. And that's a big major plus for us. And the window we have now, 150 years. Because Trump knows this. He recently issued an executive order, as you'll learn, that sounds exactly like me. I could have written it. And I'm pretty sure Bondi's on board, and I know the current justices are, and you're going to learn all about that too. Going back almost 6 years now to a case called Texas v. California, and a later one called Alabama v. California. And you're going to learn exactly what I'm telling you, but from the malice of the conservative justices on the court. And this is where we want to get to. As we get our case there in the original jurisdiction, we're going to learn we have a right to do it. Um, and that's what stops things dead bang, because we do have rights and we're not subject to a government in which we're not represented in any department thereof. And you're going to learn that too. Where's the consent of the governed here? Not there. Not due process, equal protection, any of that BS 14th War Amendment nonsense. But you assert real issues, and the Supreme Court itself, in its informal rules, has stated, that they will not rule on an issue of constitutional law in the advance of the necessity of deciding it. You don't ask, we won't answer. And today, nearly 90 years later, the problem is that all they recognize today at this particular moment in time are State Bar Association attorneys, Inc. And on a rare occasion, a pro se litigant gets it, and that's what they think we are, pro se, with specious, frivolous, sovereign citizen argument. The case just gets tossed, you never get heard. And a big problem with that, especially in the U.S. Supreme Court, but even in the trial court, quote unquote, aka administrative tribunals, if we don't know if we're wrong, let alone why, wow, the magnitude of the issues here, how do we know how to uh, consult our representatives, instruct them actually, to make the changes we want, or nominate and elect those who will make the changes? We can't do that, and as you're going to learn, send me an email, youincourt@gmail.com. We haven't had a lawful election here since very arguably November of 1864. And I am not kidding here. Nothing remotely like the election that we're supposed to have. And we want to get back to that too, because then most of the power shifts not only back to the states, but back to the county level, particularly with education. And now they start teaching the real history, of the United States and of your individual state. And the kids graduate with this knowledge. When they get on jury pools, and they're going to know they have the power to rule on the facts and the law. That's a common law judicial court principal and agent relationship. Unfortunately, the government today, the New York gangsters, think that it's morphed over, to a guardian and ward relationship, more commonly known as master and slave. And you're going to learn all about that too. Send me an email, youwincourt@gmail.com. So we do have some work to do here, but we have the window. Everything is in place like it hasn't been. Wow, I'm amazed. I'm glad I made it this far, being 77 and great health. I'm thankful for that every day so I can help keep you, your family, and your posterity, to learn their rights so they don't get caught up in all this BS. And also that human rights have value. Human life today is considered worthless because there are no recognized, lawful, deserved, just sanguineous state citizens who have common law rights. That's how good it is. And it just, hold on a sec here. There we go. Okay, anyway, that's that's how good all of this is for us, that we do have rights and we can invoke them. So that said, send me an email, youwinnincourt@gmail.com. You're going to learn a whole lot more about that, like my constitutional defense document packet materials, very modestly priced. And you can go in and start invoking jurisdiction and potentially do it in several ways if we need to at the same time. You're going to learn all about how that works too. But we're right, they're wrong. Get over it already in Washington, D.C. We got you dead bang. So that said, remember to subscribe, like the videos, tell your friends, get the word out. The sooner we start invoking our rights in the correct way according to the Constitution, the quicker we get back to where we should be, and it's great for you, your children, and your posterity. Thank you.